Okay, well, welcome everyone to the FYI by Find Your Influence, a monthly webinar series designed to unite all stakeholders within the influencer marketing industry. Each month, we will feature industry experts such as Michael and Raro, and leading a discussion around a relevant or timely topic that will hopefully lead to igniting connections that inspire us all. My name is Jamie Reardon Evans, and I'm the CEO and co-founder with Find Your Influence. I'm pleased to initiate today's discussion that will help familiarize you with recent changes from the FTC, which is guiding influencer content and endorsements. Our goal today is to introduce you to the lead attorney with the Federal Trade Commission, who helped craft updates we will discuss today surrounding influencer disclosures. I'll start by introducing today's moderator, Raro Lae. Raro is a media personality and an event host and a senior account manager at Find Your Influence. Find Your Influence launched in 2013, and we were one of the first industry's all-in-one influencer marketing solutions. And over the course of the last decade, FY has grown its opted-in community of influencers and has launched a discovery tool helping brands and agencies reach over 25 million influencers around the world. Next, I want to introduce you to Michael Ostheimer, which we are thrilled to have. Michael is a senior consumer protection attorney in the Federal Trade Commission's Division of the Advertising Practices, with over 30 years of experience. He led the FTC's review of its endorsement guidelines and is a leading rule maker on deceptive consumer reviews and testimonials. Before we start the questions, a couple housekeeping items. All cameras are off. All of the elements are muted. And then on top of that, we're going to save all questions that anyone else has until after. So because of the time frame, we have the questions compiled, and hopefully that gives you a wonderful overview of where the FTC endorsements are. And then any other questions, please feel free to join the community and follow us on both LinkedIn and our Facebook group, and you'll see much more there. But without further ado, Raro, I'll go ahead and have you kick it off with the questions.
Thank you so much, Jamie. And thank you for joining us today, Michael, for what I know is going to be an extremely transformative conversation today. So jumping right into it, for those who may not be familiar, could you start with an overview of the Federal Trade Commission and what exactly is it and what is its role within the world of influencer marketing?
Nice to meet all of you, and looking forward to this today. The FTC is an independent federal agency, which is led by a 5-person commission. Most of the FTC's legal powers in the consumer protection area come from Section 5 of the FTC Act, which broadly and generally prohibits businesses from engaging in unfair and deceptive practices. A deceptive practice involves a material representation or a failure to disclose that is likely to mislead consumers acting reasonably. The FTC has been working really hard to ensure that consumers are not harmed by misleading endorsement practices. We brought and continue to bring cases against those who violate the law. Last month, we updated our endorsement guides. We've also used warning letters to warn companies and influencers about the consequences of using deceptive endorsement practices. In addition, the FTC staff publishes consumer and business education. Guides are official interpretations of the FTC Act by the Commission. They aren't regulations, so we still have to prove that practices inconsistent with the guide are deceptive or unfair along the lines I explained earlier. The endorsement guides explain how the FTC Act applies to endorsements in advertising. An endorsement is an advertising message that consumers believe reflects the views of someone other than the sponsoring advertiser, other than the brand that's paying for the advertising. One section of the endorsement guides that's particularly relevant to influencers is a section on material connections. The guides say that if there's a connection between an endorser and a marketer that consumers would not expect, and which would affect how consumers evaluate the endorsement, affect its weight of credibility, then the connection should be disclosed.
Awesome. Thank you so much for answering that for us, Michael, and even jumping into this because I know there was a new guideline that was issued in 2023. However, prior to this, the last update to the influencer/endorsement guidelines was in 2019. Can you walk us through the process of how the FTC collected information from the industry to get us to the new guidelines that were issued in June of 2023?
Actually, the last update to the endorsement guides was back in 2009.
Got it.
And
Wow. Okay.
every 10 years or so, we review our rules and guides. So in February of 2020, we sought public comment on a number of questions regarding what changes, if any, should be made to the guides. I mean, there's been a lot of stuff that's happened since 2009.
Yeah.
And we received just over 100 comments. We reviewed those comments and we published proposed changes to the guides in May of last year. And we asked for comment on those proposed changes. We reviewed the 30 comments we received and we refined some of our proposals. And then, as you mentioned, we published revised endorsement guides last month. We have a separate business guidance document called the FTC endorsement guides, what people are asking, in which staff answers a number of frequently asked questions on the endorsement guides. And when we updated the guides, we also updated the FAQ document, the frequently asked questions document. And we did that based in part on the issues raised during the review of the endorsement guides. Like some people asked us to get in the nitty-gritty of how disclosures should appear or what words to use. And we didn't think that was appropriate to put in the guides, but we put a lot of that in the FAQs. We also added questions based on, we have a mailbox where we can get questions from businesses, brands, influencers, and other endorsers about how to comply with the guides and with the FTC Act. And we added questions to our FAQs based on the questions we received in that email box. And just so you know, you guys, anybody here can use that email box to ask us a question. And the email box is endorsements@ftc.gov.
Nice. And thank you for providing that email as well, because I'm sure a lot of people are going to have questions. So that's excellent. So at a high level, what has changed in the endorsement guidelines that are relevant to influencers?
Well, I'll tell you about that. The first thing probably isn't relevant to any influencers in this audience, but we adjusted the definition of endorsement so it covers virtual influencers and it might be relevant to some of the brands, just not some of the influencers, since you're all probably real. We also said that tags can be endorsements.
Okay.
And that the guides consist of general principles and of examples illustrating those principles. And one new example said that a paid social media post by a pro golfer showing a video of the golfer hitting golf balls is an endorsement if the golf balls are identifiable. Another new example says that a video game influencer paid to stream themselves playing an identified video game and seeming to enjoy it is an endorsement, even without an express recommendation. They don't have to say, you should try this great game. They could just be playing it and seeming to really love it.
Right.
We also tried to do a better job explaining material connections. We now say that they can include monetary payment, the provision of free or discounted products to an endorser, regardless of whether the advertiser requires an endorsement in return. They can also include other benefits to the endorser, such as early access to a product or the possibility of being paid. We do acknowledge and try to make it clear that some connections may be immaterial, meaning may not matter to consumers because they're too insignificant to affect the weight of credibility given to the endorsement. And if they're immaterial, they don't need to be disclosed. We also say that a material connection needs to be disclosed when at least a significant minority of the audience for an endorsement doesn't understand and expect a connection. So if almost everyone understands a relationship, then no disclosure is necessary.
Got it.
I mean, just like one example, I mean, I really can't imagine that anyone doesn't know that Michael Jordan, works for Nike. But as an aside, let me note that what's immaterial and what's understood aren't always easy to answer. And our advice is, when in doubt, disclose. I mean, there may be some significant percentage of an audience who just doesn't know about a connection and which should care. So we always advise, if in doubt, disclose. We added a statement to the guides that that a disclosure of a material connection doesn't require the complete details of the connection, but that it must clearly communicate the nature and significance sufficiently for consumers to evaluate its significance. We added an example about the need to disclose paid links, affiliate links. We've always said that necessary disclosure should be clear and conspicuous, but the revised guides now have a definition of what that means. Clear and conspicuous means the disclosure is difficult to miss, that is easily noticeable, and also easily understandable by ordinary consumers. If the claim requiring a disclosure is made visually, then the disclosure should be made visually. And if a claim is made audibly, then the disclosure should be made audibly. If the claim is both made visually and audibly, the disclosure should be made both ways. And simultaneous visual and audible disclosure is more likely to be clear and conspicuous. A visual disclosure should always stand out from any accompanying text or visual elements, so it's easily noticed, read, and understood. And an audible disclosure should be delivered in a volume, speed, and cadence, so that ordinary consumers can easily hear and understand it. No fast talking like I'm doing right now. In communications using electronic means such as social media, the internet, the disclosure should be unavoidable. The revised guides give a few examples of what it's not a clear and conspicuous disclosure. For example, a disclosure on an influencer's profile page isn't clear and conspicuous. A disclosure that requires clicking more, such as on Instagram, isn't clear and conspicuous. And a built-in disclosure tool that briefly superimposes a disclosure in small white text against a light background on an image, which competes with other superimposed text, that isn't clear and conspicuous. Another new example says that even if a disclosure is clear and conspicuous on a computer, it isn't good enough if it's not clear and conspicuous on a smartphone. Yet another example says that if a marketer reposts a paid social media endorsement, it should add a disclosure if the original post did not have a clear and conspicuous disclosure, or if it had a disclosure that doesn't appear clearly and conspicuously when reposted. Mostly though, we discuss and explain the nitty-gritty of particular disclosures in that staff business guidance document I referred to earlier, the FAQs. We also expanded a section of the guides on the potential liability of various parties and of what advertisers should do. Advertisers are subject to liability for misleading or unsubstantiated statements made by their endorsers, or for failing to disclose unexpected material connections between themselves and their endorsers. And an advertiser may be liable for a deceptive endorsement, even when the endorser is not liable. The revised guides explain that to reduce an advertiser's odds of facing an FTC enforcement action, it should have a good program. And it explains what that should be. The advertiser should provide guidance to their endorsers on the need to ensure that their statement is not misleading, and to disclose unexpected material connections. And the advertiser should monitor their endorsers' compliance, and they should take action sufficient to remedy non-compliance and prevent future non-compliance. By the way, in that staff business guidance document, which I mentioned, we say it's even better and easier to just require pre-approval of all influencer posts rather than to have to look for them. If they're all pre-approved, you know what your influencers are saying. Back to the guides, they say that an endorser may be liable for making a claim that the endorser knows or should know to be deceptive, such as falsely representing that they personally used a product. So if you're an influencer and you say you used a product or suggest you used it, you should use it or have it. Endorsers also may be liable for failing to adequately disclose unexpected material connections between themselves and an advertiser, such as when the endorser creates and disseminates social media posts without disclosures. I'm almost done on this one, but it's a long answer. I'm sorry.
No, this is very great information.
The guides say that advertising agencies, PR firms, review brokers, reputation management companies, and other similar intermediaries may be liable for their roles in creating and disseminating endorsements containing representations that they know or should know are deceptive, and that they also may be liable for their role with respect to the failure to disclose material connections, or for their role in directing and hiring endorsers who fail to disclose their material connections. And again, there's a lot of new stuff that's in the FAQs, and I'd really, really suggest that people take a look at the FAQs. I mean, they're 50 pages, but they're really easily written, common sense language, and I'd suggest people take a look at those.
Thank you so much. And we may have already touched on some of these items in the next question, but just in case we didn't, I'm going to ask the next question. So admittedly, the format of the new guidelines is not a traditional document we're used to consuming in the influencer marketing. And we're thrilled to have you here to help us better understand so all stakeholders can continue to grow within the established guidelines. So as it is now, does the FTC offer a checklist that brands and influencers could keep on hand with a list of do's and don'ts when creating and posting sponsored content?
Well, we don't have a checklist.
Okay.
But again, I'd suggest reading the FAQs.
Yeah.
And we do actually have a very short pamphlet written for influencers.
Okay.
It's called Disclosures 101 for Social Media Influencers. And it's on our website. And I think it's just a few pages, and it would be helpful to an influencer.
Awesome. Thank you. And when is the effective date of these guidelines?
Well, the guides aren't regulations. So they don't have an effective date.
Okay.
They're interpretations of what the law is, so they currently apply.
Okay. Got it. And lastly, what if influencers have posted content since June of 2023 that is not in compliance? Do they need to go back and remedy these previous posts?
Well, if they said something that isn't true, then they should definitely change that. And if they needed if they made a post that needed a disclosure and they didn't have a disclosure, I'd suggest adding one.
Got it. So we have seen highly regulated industries like the financial and the pharmaceutical industries, to name a few, that have their own set of required disclosures for sponsored content. Can you confirm that the FTC still requires brands and influencers to follow the updated endorsement guidelines on top of the regulator guidelines?
If the FTC has jurisdiction, then the FTC Act applies to sponsored content. A disclosure that satisfies another agency might or might not be sufficiently clear and conspicuous or address the material connection issue. So I can't really answer that question. I don't personally know enough to comment on what other agencies require with respect to sponsored content disclosures.
Got it. Okay. So while all of the endorsement guidelines are equal in importance, what single guidelines do you see brands and influencers miss the most often?
It's probably the need for clear and conspicuous disclosures to material connections.
Got it. And I think a lot of people who are on this call can definitely agree, because we all have probably seen it at one time or another. So with TikTok or any form of video, what are the disclosures that industries need to know and follow in addition to #ad or #sponsored?
Well, in the FTC FAQs, the FAQs I keep mentioning, we say that a disclosure in the TikTok text description is very likely to not be clear and conspicuous. It's in small print, it doesn't stand out, and it often doesn't contrast against the background of the video. Also, TikTok videos often have many competing elements. When content creators want viewers to read something, they superimpose much larger text over their videos. And as I said earlier, if an endorsement is made in the audio portion of a video, a necessary disclosure should also be made in the audio. So, I mean, superimposed text can work if there's a claim in the visual. An audio statement can work if it's made in the audio. With respect to the language of the disclosure, it's fine to label or describe the endorsement as an ad or a sponsored, but there's a lot of other language that one could use as long as that language is unambiguous. We address a lot of potential disclosure language in the FAQs on what is and isn't, in our opinions, ambiguous or unambiguous.
Okay. Awesome. So how do creators and brands need to consider disclosing this within their video content? I know you did mention a little bit, there might be some competing elements, but if they were to do it correctly, what would that look like?
Well, if a claim is made in the visuals of the video, there should be an overlay disclosure in the video. I mean, it should be close in time to the endorsement, and It should be big enough and contrasting enough and on the screen long enough that people can easily notice it, no matter what else is going on in the video. I think that really answers that question.
Yeah, it does. Thank you. And I know you mentioned it potentially being a video overlay, but then it also could be disclosed in the caption as long as it's not ambiguous, essentially.
No, I didn't say if there's a claim in a TikTok video or an Instagram video, I didn't say that a disclosure in the caption would be good enough. Because somebody can easily watch the video without reading well, first of all, TikTok captions are probably never clear and conspicuous for the reasons I said before. They're really tiny, they're not contrasting, etc. But even an Instagram caption can easily miss. I mean, people are scrolling through their feeds, a video starts playing and they start watching the video. They're not necessarily going to read the caption, they'll just watch the video. So I wouldn't say the disclosure in the caption is good enough. What I said was that if there's a claim in the visual of the video by XYZ brand or something else or whatever it is, then there should be a disclosure in the video, visual portion. And if there's an audio portion that makes an endorsement, then there should be a disclosure in the audio portion. As far as the caption, I mean, if the caption itself makes an endorsement, then there should be a disclosure in the caption. And one of our native advertising principles is that someone should know that something's an ad before they open it. So it's still best to have a disclosure in the caption, even if there isn't a claim in the caption, an endorsement in the caption.
Got it. And so are the guidelines applicable across all social media platforms like Instagram, TikTok, Pinterest, etc.? Or are there specific disclosure requirements per platform?
They're applicable across all the platforms. I mean, there are nuances as to how posts work across platforms that could affect how disclosures should appear. For example, I mentioned earlier that on Instagram, I think only the first 2 or 3 lines of a post appear without clicking more. So if there's a claim in the first 2 or 3 lines and there is a disclosure that you only see by clicking more, then that disclosure isn't clear and conspicuous. But I mean, the principle and the guideline is still applicable across all platforms.
Got it. So Michael, oftentimes influencers can live stream content or include sponsor content within a podcast. How should these partnerships be disclosed?
Sure. Viewers can start watching the stream at any time, so they could easily miss a disclosure at the beginning of the stream or at any other single point of the stream. If there are multiple periodic disclosures throughout the stream, people are more likely to see them no matter when they tune in. To be on the safe side, you could have a continuous, clear, and conspicuous disclosure appear throughout the entire stream, not screen. This would be particularly true for a stream, which is in essence one long endorsement, like video gameplay. If the endorsements are discrete, like somebody's talking about various items or they just mention at minute, one particular point in time, some product, then there could be a disclosure right before each or right before or during each endorsement. As to podcasts, there could also be a disclosure before each endorsement. By the way, we have a new example in the guides saying that what's clearly an ad at the beginning of many podcasts doesn't need a disclosure because listeners would likely expect that a podcaster was compensated for that thing that's clearly an ad. I've listened to many podcasts where they start off by saying, now I want to tell you about a great something. Right. And it's obviously an ad. So there doesn't need to be any disclosure. The example though does continue by stating that the ad might communicate that the host is expressing their own views. And in that case, the host would actually need to hold the views expressed.
Got it. And so we know that influencer marketing is a global strategy. How do these guidelines extend to content posted in non-English languages or content targeted to an international audience?
As to international marketing, if it's reasonably foreseeable that it will impact US consumers, then the FTC does have jurisdiction and our rules apply. Also, many other countries have similar laws and policies relating to endorsements, So it's for that reason too, it's another good reason to, make disclosures. One of our FAQs addresses a question from a Spanish language influencer. And the answer says that the connection between an endorser and a marketer should be disclosed in whatever language or languages the endorsement is made.
Okay. That is very helpful. Thank you.
Sure.
And so in the world of de-influencing now, as we understand it from the new guidelines, influencers need to disclose if they have a partnership with a competing brand, they are de-influencing. Can you walk us through this to better understand why this is important to disclose?
Well, yes, one of our FAQs says that. It says that if you criticize a competitor of a brand you're paid to endorse, you should disclose your paid relationship. The reason is that it would likely affect the weight of credibility that your audience gives to your negative comments.
Right. I think that's very good. That's great that that's even being addressed, especially because some strategies actually do incorporate that. So that's really good to know.
Yep, we've required about it.
Yeah. When it comes to a brand gifting product to an influencer without a requirement of posting on social media, how should an influencer approach posting content with the product if there was no financial compensation?
Well, viewers may assess an influencer's comments differently if they knew the influencer got a product for free. So we advise disclosing that fact. They could say, thanks XYZ for the free product, or thanks XYZ for the gift of ABC product. If that's too long, they can always say that you use the disclosure ad, something like that.
Right. Okay, cool. And so how should the brand or agency message FTC disclosure guidelines when sending gifted products to the influencers?
If a company sends influencers a free unsolicited product and nothing else, it should ask them to clearly and conspicuously disclose the gift in any resulting social media posts or other endorsements. Tell them how it should be disclosed and ask them to tag the brand. The company should monitor all resulting tagged posts. We understand that there are software solutions that exist to monitor compliance online. The FTC doesn't take any position on their quality and recognizes that software like that might be too expensive for some companies. The extent of compliance monitoring needed, whether or not to use such software, may depend upon the types of products and possible claims involved. For example, if the claims involve health or safety. If they involve health or safety, proper monitoring to make sure somebody doesn't make improper, efficacy claims, for example, would be more important.
Absolutely. So I know we talked a little bit about gifting, but want to shift gears over into affiliate links. So when it comes to influencers sharing affiliate links where they're earning a commission, how do the disclosure requirements differ?
Well, we advise disclosing affiliate links, and our FAQs have a whole section that addresses it. And they say that paid links right next to an affiliate, the word paid link right next to an affiliate link would be an adequate disclosure as to the nature of the link.
Okay.
And there's other ways to do it, but that's one way that we say is effective and only requires 2 words.
Right. Absolutely. So today on Instagram, influencers can use the paid partnership tool to demonstrate to viewers that they have been paid. Is that still enough or are additional disclosures needed?
Well, it's good that some platforms offer these tools, and we don't want to dissuade you from using them. But just because a platform offers this feature is no guarantee that it's an effective way for influencers to disclose their material connections to a brand. In an investigation, the FTC would evaluate whether the use of the tool by itself clearly and conspicuously discloses the relevant connection. Indeed, for any disclosure in social media, whether or not through the use of a platform tool, the FTC would consider several key factors in determining whether the disclosure is clear and conspicuous. One factor is placement. The disclosure should catch users' attention and be placed where they aren't likely to miss it. A key consideration here is how users view the post on a particular platform. For example, on a photo platform, users paging through their streams will likely look at eye-catching images. Therefore, a disclosure placed above a photo might not attract their attention. Similarly, a disclosure in the lower corner of a video could easily be missed by users. A second factor is readability. The disclosure should use simple to read font with a contrasting background that makes it stand out. And not all tools do that. A third factor is clarity. The disclosure should be worded in a way that's clear, unambiguous, and understandable for ordinary consumers. For example, simply flagging that a video contains, quote, contains paid content might not be sufficient if the video mentions multiple products or services without identifying which content is paid. The big picture point is that the ultimate responsibility for clearly and conspicuously disclosing material connection rests with the influencer and the brand, not the platform. To be on the safe side, it's always best to add your own disclosure, even if a platform offers its own disclosure tool. It would be highly beneficial if all social media platforms develop standardized built-in disclosure tools that are easy for endorsers to use and easier for viewers to notice and understand. And if the platforms also tested the effectiveness of such disclosures. I mean, FTC staff's always willing to discuss this with the platforms, and we hope they'd make improvements in their disclosure tools, but we haven't blessed any of them.
Got it. So if an influencer's content isn't following the guidelines and the FTC were to issue a fine or a notice for non-compliance, does the burden fall solely on the influencer?
Well, first of all, we can't issue fines,
Okay.
but depending on what occurred, we can seek other monetary remedies.
Got
If
it.
law enforcement becomes necessary, our focus would usually be on the advertisers or their ad agencies and PR firms.
Got it.
However, action against an individual endorser might be appropriate in certain circumstances. For example, if the endorser hasn't made required disclosures despite previous FTC warnings.
Got it. And what role does the advertiser have in an influencer's non-compliance?
As I said earlier, advertisers are responsible for what their influencers do. As I also said, advertisers can reduce their exposure by having a good compliance program. And I kind of described that earlier.
Got it. Okay. And so how should influencers, brands, agencies, or any out of compliance party expect to receive communication from the FTC when a violation has been found? And just to clarify, to be sure, influencers and all impacted parties recognize communication from the FTC and as legitimate and not a scam, will that come via US mail, email, DM, or some other way?
We usually communicate by Federal Express or mail, postal mail.
Okay.
But we have reached out to brands and to influencers by email when we couldn't find another means to communicate with them, or when we didn't get a response to a letter.
Got it. Okay.
But obviously any emails would come from an @ftc.gov address, and you could probably look up the FTC attorney who sent the letter on our website or on the internet.
Got it. And what are some of the additional key updates influencers and brands should know that we didn't have the foresight to ask you today?
Well, as I keep saying, that there's 50 pages of new and revised Q&As, FAQs, and I can't even possibly cover a fraction of those. But let me give you a taste of maybe 5 or 6 of them. Question: can a brand hire several influencers to post the same content created by the brand and not the influencers themselves? For example, a picture for a Facebook post or a pre-written text for a tweet. Answer: yes, but you need to ask yourself whether the post conveys something that isn't true, like the influencer used the product, and if they didn't use it, that would be a problem.
Right.
Question: I'm under contract with a brand, and by now my followers might have seen maybe 8 disclosures that I'm working with a brand. Do I have to disclose the relationship in every post going forward? Answer: each new endorsement made without a disclosure could be deceptive because viewers might not have seen the prior posts. Question: a year ago, I was given a $60 video game and nothing else in exchange for live streaming my gameplay. I still love the game and stream it. Do I still need to make disclosures after a year? Answer: how long it would be reasonable for you to make disclosures really depends on the expectations of your fans. After some period of time, it probably wouldn't matter to them that you got it for free. If you're choosing to play a game after a year, after you got it for free, it probably means you really like it. You really, truly like it, and you don't need a disclosure. Question: I'm an influencer and a company sent me a free product and nothing else, which I posted about. If I buy more of the product with my own money and continue using it, Can I post about it without disclosing that the company once sent it to me for free? Answer: if you have an ongoing relationship with that brand, you should still disclose that relationship, even if you buy the product yourself. If you don't have an ongoing relationship, your viewers probably wouldn't care that you initially got the product for free. And lastly, question. My paid video reviews recognize our product's good points as well as its negative ones. Since it recognizes negative points, is it still really an endorsement? Short answer, yes, it is. And only other thing I'd keep saying is over and over, I would highly recommend reading our business guidance, the FAQs, and that influencers look at our 101 for influencers document. And I'm happy at this point, if there's any time left, I think there's maybe 20 minutes, 15, 20, 25 minutes left. I'm happy to take any questions that your audience has.
Awesome. And Jamie, let me know, did you want to lead the Q&A?
Sure, you know what? Let's look here. Bear with us 1 second. We're pulling this up.
That's fine.
Okay. How do we know if we are being audited by the FTC as a creator and influencer? How are the creator agencies being held accountable for these rules and regulations?
You mean, how do you know that you're being investigated by us? Well, at some point during an investigation, we would contact the person where the business influencer or entity that we're investigating. But until we contact them, there's no way to know.
Looking through a couple more, there's some duplications. So
Sure.
The good news is you've tackled a lot here. And there's a lot of questions around links and the guidelines. So we'll go ahead and send those out after. Yep, lots of, can we get links to the FAQs and to the guidelines?
Good.
That will be coming. Do still photos need to have disclosures on the assets visually? I think we tackled some of that.
It depends on if the still photo makes an endorsement in and of itself. I mean, if it does, then yes, there could need to be a disclosure. Although, I mean, it depends on the context. I mean, if somebody's looking at a still photo on like a Facebook link, a Facebook page, I mean, the disclosure in the caption might, if it's clear and conspicuous, would probably be good enough.
Perfect. So what are the best practices for working with creators secured outside of the United States, but are representing, advocating for a brand located in the US? And then is there any collaboration with other governing bodies on disclosures and requirements? So that's a good question.
I'm sorry, the first question was, yes, if you're working with influencers outside the United States, you contractually and otherwise, you can make requirements on what they do and don't do. You also can ask them to have you pre-approve you can explain to them what they need to do. You can tell them how disclosures should be made. You can require pre-approval of their post, and you can even say that you won't pay them until after you've approved their post. So I mean, there's all sorts of things you can do. As far as do we collaborate with other other foreign agencies? Yes, we do. We collaborate with consumer protection authorities in other parts of the world.
Perfect. Thank you. Does a disclaimer on a video need to be on screen throughout the entire video or just during the portion with the brand claims?
Well, I mean, I don't think it needs to, I mean, putting aside the issue of a live stream where somebody could tune in, there's no reason to have a disclosure on the screen throughout. I mean, at least if we're not talking about kids, if we're not talking about little kids, put aside little kids on everything. With respect to adults, I mean, a disclosure that's on the screen long enough for people to read and notice it, it's adequate if it's just there at the time of the endorsement.
Yeah. Terrific. Are there different guidelines when the endorsement involves alcohol?
Are there different guidelines? I honestly don't know. Well, there's no guidelines with respect to the FTC Act. I mean, we have that I know of, but I mean, there may be other requirements either by industry self-regulation or by alcohol, tobacco, and firearms. I don't really know. I know that we did send a warning letter to an influencer who was basically endorsing eating breakfast cereal with alcohol, and that violated at least self-regulatory guidelines and seemed problematic to us. But it doesn't require a different disclosure with respect to material connections. It's the same.
Okay, perfect. Another question on the affiliate network. So it says, are affiliate networks held liable for the actions of influencers that utilize their affiliate links?
Yeah, thank you.
What's the appropriate disclosure when an influencer is hosted in a paid capacity by a CVB, so a Convention and Visitors Bureau, restaurants, hotels?
I'm sorry. So an influencer is being hosted by a convention or something? I'm sorry, could you explain that? I mean,
Yes, it's the Convention and Visitors Bureau. So
Mhm.
the disclosures, if there's anything different with the disclosures for.
Yeah, I mean, yeah, we actually addressed that, I think, in the FAQs. I mean, a disclosure that simply says the word hosted wouldn't be clear. I mean, I don't think people would know what does hosted mean if that's the only word for the disclosure, hashtag hosted. But I mean, if the endorser said something like, thanks for the free stay to, XYZ bureau or hotel, that would be great. Or even, it might even be good enough to say, complimentary stay, or something like that. But just the word hosted by itself would probably be ambiguous.
Perfect.
And I mean, I didn't give a disclosure, a very important disclosure at the beginning of this talk. The first important disclosure I should give is that the views I've been expressing all along are my own and do not reflect those of the FTC or any individual commissioner. I'm supposed to give that, and I forgot to. But also, what I said before, everything I said before we started doing these questions at the end is stuff that the FTC has written, either staff or the commission has written. But some of these fly by the answers, such as complimentary stay. I mean, this is my own on the spur of the cuff answers.
Terrific. If you win a giveaway, do you need to say that your prize was gifted?
I don't know what you mean by if you win a giveaway. I mean, if there is it that people are attending an event for influencers and they're going to give away? Or, okay, that's what I thought you meant. Yes, if you got something, if it's not open to the general public and it's basically to encourage you to promote their product, that it's just for influencers, yeah, you should say that you got this for free if you post about it, even if only 1 out of 20 people get that thing for free. And gifted, as I don't know if I said this earlier, just the word gifted by itself is probably not. We don't think that's a clear and conspicuous disclosure. I mean, gift from XYZ company or free whatever from this XYZ company would be much clearer, and just the word gifted is ambiguous.
Perfect. And in terms of this giveaway, and I see Renee, your comment here, this giveaway would be open to the public. So I don't know if that changes your.
Well, I mean, if there's just I'm sorry. If somebody just has a raffle or a lottery giveaway and they don't require any social media post as a result of it, that's one thing. I mean, if they're saying the winner needs to post in social media, as part of the prize winning, and then there should be disclosure.
Terrific. And I think we just got through the additional questions, and I appreciate you taking the time to answer these as well. But Michael, it's been such a treat.
It's my pleasure. Thank you.
Thank you for walking us through this. And then what we'll do is we'll send out the guidelines, any additional FAQs that we worked with you on. So we'll distribute those in the next couple of days with Michael, with your blessing.
Sure. I mean, what I'd suggest, at least most importantly, I'd suggest sending a link to our FAQs, the frequently asked questions document, and to our Influencers 101 document. I mean, you could also, the FAQ document also has a link to the guides themselves for those who want to actually read the guides. The guides are written more for lawyers than for brands or influencers, but they're also worth looking at. They're not in gobbledygook, but they're not as easily understandable. So I'd read the FAQs and the Influencer 101, and some people might want to look at the guides. Perfect.
That sounds great. So this recording will be coming soon, as well as all the other details. And then again, Michael, Raro, thank you so much. And thank you all for joining us today. We have another webinar coming up on Thursday, August 17th at 1 p.m. Eastern. So please feel free to join us for that as well. And again, Michael, thank you so much.
Thank you. Goodbye.
Bye-bye.
Bye. Thank you.